Joumana Kayrouz. You've seen her images on giant billboards across the metro. Joumana Kayrouz. You've seen her images on buses across the city. Now get to know Joumana Kayrouz.
The war broke out in my home country, Lebanon. I was 11 years old, and I saw a lot of bloodshed and inequality and poverty. You can't grow up in an environment like that and not be affected by it and not want to make a difference. I graduated from Yale University with a master's in ethics. I speak 4 languages. It has always been innate in me fighting for the underdog and trying to do whatever it is I can to make a difference in the world.
Let Joumana Kayrouz protect your rights. Call the law offices of Joumana Kayrouz at 1-866-YOUR-RIGHTS, extension 100, or visit yourrights.com.
برنامج يور رايتس مع المحامية جومانا كيروز المختصة في قضايا حوادث السيارات، مع نخبة من المحامين في اختصاصات عدة منها الطلاق والهجرة والإفلاس، يأتيكم الآن على الهواء مباشرة. أسعد الله أوقاتكم بالخير مستمعينا في كل مكان. حلقة جديدة من برنامج يور رايتس مع المحامية جومانا كيروز. دائما بإمكانكم المشاركة في البرنامج في موضوع الحلقة المطروح على الأرقام 313-769-6666 519-256-1023. مكاتب المحامية جومانا كيروز تستقبل قضاياكم المتعلقة بالقضايا المتعلقة بالبيرسونال انجري بشكل عام، منها قضايا حوادث السيارات، قضايا الهجرة والتجنس، قضايا الإفلاس، كريمنال لو، فاميلي لو، قضايا ضمان اجتماعي وإصابات العمل. 248-557-3645. الاستشارات مجانية. 248-557-3645. حلقات برنامج يور رايتس يعاد بثها على الموقع الإلكتروني yourrights.com/radio أو على اليوتيوب. كل ما عليكم البحث عن قناة جومانا كيروز. أما مواعيد حلقات برنامج يور رايتس فهي من الاثنين وحتى الجمعة مبدئيا في 1 ظهرا، وابتداء من الأسبوع اللي راح يكون 6 بالشهر ولا لا؟ امتى راح يكون؟
الأسبوع ببلش بثلاثاء الاثنين القادم August
12 ولا على 16؟
ابتداء من August 12 بنصير كل يوم الساعة 1.
تمام، ابتداء من August 12 بالفعل
يعني بعد 4-5 أيام.
صح. فإذا الموعد الجديد راح يكون على 1 حتى يوم الجمعة اللي نعم. كان يعني سابقا أو الساعة 3 الظهر. نعم. أيضا راح يكون ثابت الساعة 1 الظهر. أعتقد هذا الشيء يعني كثير مستمعين رحبوا بالفكرة أنه يكون البرنامج متواصل على طول الأسبوع حتى يوم الجمعة أنه يكون الساعة 1 الظهر أيضا.
طبعا رامي صباح الخير. قبل كل شيء لك وللمستمعين ولضيفنا اليوم. رامي أسهل بكتير إنه المستمع يعرف إنه البرنامج ثابت كل يوم الساعة 1. وإنما بالإضافة أنا لاحظت أن يمكن ملاحظتي غلط، بس لاحظت إنه نهار الجمعة حبينا نتركه 3 احتراما للمستمعين المسلمين اللي بيكونوا عم بيصلوا. لاحظت إنه الساعة 3 بفتكر إنه في مستمعين خلص يعني ما بقى حابين يتعلموا مواضيع صعبة مثل قانون الفاميلي لو والكريمنال لو، وبلشوا يفكروا شوي انه اتس ويكند. بعرف انا شخصيا وقت اللي بيجي نهار الجمعة الساعة 3 اغلبية الاوقات مرهقة. يعني عندي صعوبة لحتى امشي بالبرنامج صح. واعطي من كل قلبي. بتصور متهيألي ويمكن انا غلطانة انه المستمعين الساعة 3 بعد الظهر are already in weekend mode. بالإضافة إدارة الراديو قالت إنه الدراسات اللي عندهم أو الأرقام اللي عندهم بتفرجي إنه الستريمينج الساعة 1 أعلى من الساعة 3. ليش لا؟ مستعدين إنه نحطها الساعة 1. بتعرف مثل كل شيء بتجرب، بيمشي بتكمل، ما بيمشي بتركز بتزبط بتغير you adjust. إن الله راد بفتكر رح يمشي الأمر. إن الله راد ابتداء من الاثنين القادم، ونحن بنعتذر عم نضل نغير على المستمعين بس بإذن الله من بعد.
أكيد مصلحتهم بالأول بالأخير على فكرة إنه النسبة الأكبر أكيد يهمنا إنه توصل معلومات لعدد أكبر من المستمعين.
نعم، وبفتكر صار أسهل لهم إنه يعرفوا إنه إذا بهمهم يتسمعوا عن موضوع قانوني معين ما عليهم إلا إنه تونن الساعة 1 بعد الظهر. ابتداء من الاثنين القادم August 12 2019 رح نصير كل يوم الساعة 1 بعد الظهر.
إن شاء الله إن شاء الله. كل التوفيق. مرة أخرى رحب بك جمانة. واليوم أعتقد الحلقة رح تكون مخصصة للإصابات الشخصية، صحيح؟
نعم، مثل كل نهار أربعاء بنحاول إنه نتكلم عن الإصابات الشخصية.
نعم.
الجمعة الماضية مثل هلا كنا عم نحكي about cyber security اللي هي مش إصابات شخصية بيرسي، وإنما كان موضوع إجانا عليه كتير تعليقات، عملنا له نتفة دعاية على السوشيال ميديا، اجينا كتير فيدباك، اجينا فيدباك من غير دول، اجينا فيدباك من هون. سو كتر خير الله. اليوم مش رح نحكي عن السايبر سيكيورتي. على فكرة أنا ما ذكرت وحدة من أكبر الأتاكس اللي صارت، ومش رح نحكي عنها اليوم. ما ذكرت اللي بنحكي عنها يمكن بحلقة بالمستقبل، اللي هي على من أكبر البنوك بالولايات المتحدة اللي هي كابيتال وان. هي من الهاكينج اللي صار بدون شك. يمكن أنت بتعرف عنه معلومات أكتر مما أنا اليوم بعرف عنه. كمان حلقة امبارح رامي بعد ما حطيناها على السوشيال ميديا، حلقة امبارح كانت بالإنجليزي. بإذن الله الحلقة 3 القادم رح تكون تلخيص بالعربي أكتر. ما بقدر أقول لك قديش إجينا فيدباك أوريدي، وهو كان عن موضوع إنه شو بيصير للشخص اللي على الكريدت كاردز تبعه أقل ما يدفع هو المينيموم بايمنت. الإلستريشنز اللي استعملناهن، الأرقام اللي استعملناهن، مثل ما بيقولوا بالإنجليزي really drove the message home, really nailed it. يعني وضحت كتير للمستمعين شو الفكرة هون وشو خطورة انه الانسان يعيش على المينيموم بيمنت للكريدت كارد. نحن اليوم مع المحامي هاورد رادنر. المحامي هاورد رادنر محامي عنده اكثر من 40 سنة خبرة رامي، وهو تقريبا بالشهر بيجي لعنا، تقريبا بيجي بيزورنا هون تقريبا مرة بالشهر، وانما ما زرنا الشهر الماضي لانه كان بإسرائيل وبعده راجع من إسرائيل. هلأ بنسأله كيف كانت رحلته على إسرائيل. هو اختصاصي بالإصابات الشخصية وبالتحديد بالبريمسز لايبيليتي، يعني الإصابات الشخصية اللي بتنبع عن سليب اند فول. إنسان وقع بحجرة، إنسان راح على جروسري ستور وفي شي بالأرض، إنسان عايش بأبارتمنت، إنسان مستأجر بيت، إنسان طالع بالأليفيتر، إنسان عم بيزور هوتيل، وإلى آخره وإلى آخره. هيدي إصابات كمان شخصية لأنه إصابات إلى لجسد هذا الإنسان. اليوم we're gonna slow down، رح نحكي بالإنجليزي، رح نترجم بالعربي لنوصل هيك أفكار أساسية ومهمة جدا. Attorney Howard Radner, happy to see you today. It's been a minute since we saw you.
It's been, I think, 2 months.
A little bit less than that, but that's okay. How was your trip to Israel?
It was fabulous. It was really.
Can you tell us a little bit about it?
Sure.
Just a little bit.
Well, you know, Joumana, I have a daughter who moved to Israel.
Oh, I did not know that.
7 years ago with her family.
Yes.
She's got her husband who's a lawyer.
Okay.
And 5 children.
A lawyer here in the United States.
He was actually a lawyer in Canada.
Okay.
He's an intellectual property attorney.
Okay.
So he does patents and copyrights. So they live in Israel, and so we periodically go there to visit with them.
To visit with
and
them.
My wife has 3 sisters that live in Israel.
How beautiful.
So it's easier for us to go there every so often than for all of them to come here.
You know, it's very funny. That part of the world, it has the 3 major world religion right there. And I am sure you have visited the holy sites time and again. I mean, the birth of Judaism, Christianity, and Islam came out from that holy land. It is just unbelievable.
It is unbelievable, and I really enjoy seeing my family, but also to go up and down the country and go across the width of the country.
And you visit the holy sites?
I do. Yeah.
Did you do that?
I swam in the Mediterranean as well.
Oh, in the Dead Sea?
No, in the Mediterranean.
In the Mediterranean. Okay, very good. And was that a fun experience?
Great. I love to swim in the ocean.
Yes, yes. Well, welcome again. We're very happy to have you.
Thank you so much.
We want to tell the listeners that anybody who is listening who wants to ask Attorney Howard Radner, he is the attorney that we work with in our office, who specializes in premises liability, in slip and fall, in trip and fall, all kinds of injuries that happen to the body as a result of such events. And Attorney Howard Radner has more than 40 years of experience. 40 years? 41?
Well, I hate to tell you, I'm getting older. It's 45 now.
45, okay. 45.
In October, it'll be 45.
45 years of experience. That's really, really, really very impressive. So we have quite a bit to talk about. However, we want to say that if anyone has a question or a comment, maybe has pending cases with other law firms or has been injured as a result of, an injury at Meyer or an injury at the mall or from renting an apartment complex or a house and so forth. If they're interested to call, ask questions, the numbers to call are 313-769-6666 and from Windsor, 519-256-1023. First question I want to ask is, what is the time limit that one has to file a lawsuit if this person thinks that they have suffered an injury because of the negligence of somebody in a slip and fall, trip and fall, premises liability of any kind?
Sure. Well, generally speaking, the rule is 3 years. The statute of limitations is 3 years for negligence cases.
So that means that they have 3 years to sue.
However, if the person needs to sue the government, then the statute of limitations is 2 years. And there's also a notice requirement that a written notice has to be given to the government within 120 days of the injury.
120 days, that's 4 months.
Mm-hmm.
Okay. And the notice has to be specific enough.
Yes, there's certain requirements in there that you really need a lawyer to make sure that the notice is proper.
Okay.
If the notice is not proper, then you can't even file the suit.
It's called defective notice.
That's right. Mm-hmm.
So نحن اليوم عم نحكي عن الإصابات الشخصية اللي بتنبع عن الانزلاق ومواضيع من هي مع المحامي هاورد رادنر اللي عنده 45 سنة خبرة بهيدا الموضوع. أول سؤال سألته، قديش عنده الإنسان اللي بيعتبر أنه هو تأذى بسبب إهمال وصل لسليب اند فول، تريب اند فول، elevator accident، كتير من هيدول المواضيع، قديش عنده الإنسان ليقدم دعوة؟ القاعدة العامة هي إنه الإنسان عنده 3 سنوات ليقدم دعوة من وقت حصول الإصابة. وإنما إذا كانت الدعوة رح تكون ضد الحكومة، بعطي مثل public sidewalk، يعني إنسان وقع بجورة هو وماشي على الطريق، لنقول سلم جدلا مثلا في مدينة ديترويت، على sidewalk اللي بتملك السايدوالك هي المدينة. هيدا بيسموه public sidewalk. يعني نحن إذا بدنا نقيم دعوة ضد مدينة ديترويت، يعني هي it is the government، هي الحكومة. هون القانون بيقول إنه عنا 2 سنين فقط من وقت ما صارت الإصابة، مش 3 سنوات. وإنما بما بخص بالحكومة ما بيكفي إنه نقيم دعوة ضمن 2 سنين، بدنا نكون عاطينهم علم وخبر ضمن 120 نهار، يعني 4 شهور من حصول الإصابة. والعلم والخبر لازم يكون كتابة، والعلم والخبر مش بس لازم يكون كتابة، لازم يكون مفصل. كقاعدة عامة 3 سنوات للإنسان يقيم دعوة. وإنما إذا الدعوة رح تكون ضد الحكومة، عنا 2 فقط. هيدي أول نقطة بحب أقولها. رامي، هل عنا اتصال؟ أوكي. وعلى فكرة الإصابات ممكن تصير بباركينج ستراكشر، الإصابات ممكن تصير بشوبينج سنتر، الإصابات ممكن تصير because of falling on ice, on snow. الإصابات يعني بيكون لها أسباب عديدة. Attorney Howard Radner, there is a case that you're working on right now. We don't want to say enough because it is one of our clients and perhaps one of the listeners, that has to do with ice and snow. Can you tell us enough about the case while changing certain key facts so that no one can tell who that person is?
Sure. The gentleman was leaving his condominium and fell on the sidewalk, which was covered with ice, and sustained a brain injury. He had a subdural hematoma. He had hemorrhaging in his brain. He had to have surgery to evacuate the bleeding. And he's had many residual effects from that injury since. So he's suing the owner of the condominium complex and the snow contractor.
Okay, so let me make sure I understand. This person lives in a condominium complex.
Right.
There was ice on within the
Public
common
sidewalk.
the public.
The common sidewalk, not public, common sidewalk.
Okay, so there was ice on the common sidewalk, meaning sidewalks inside the condominium complex.
That's right.
In other words, for him to leave, he has no choice but to walk through the sidewalks.
Correct.
And those sidewalks were not properly cleaned.
That's right. They were full of ice.
Okay, not properly cleaned. And as a result of that, he fell.
He fell and struck his head on the cement.
Okay. And how is he doing now?
Not so well. He's
Not
being
so
treated.
well. And have you filed a lawsuit?
We did.
You filed a lawsuit against the owner of the condominium
And the snow contractor.
and the snow contractor. Okay. So one of the things that people think, Howard, if something bad happened, that means that somebody was negligent, that somebody did something they shouldn't have done, or somebody didn't do something they should have done. There is this automatic assumption in the brains of people, bad outcome, that means somebody was bad somewhere. And whereas that may be the case, that's not always the case. Whereas we see that in medical malpractice where you have a bad outcome and people have the right to question. They have the right to wonder whether the bad outcome was the result of some negligent behavior somewhere. And quite often, like let's say in a medical malpractice or here in a slip and fall, the lay person, the average person, does not know enough to know whether the bad outcome was the result of some negligence. Quite often, you would need to go seek a medical opinion, talk to a lawyer, in order to find out whether or not life just happened or whether or not this was preventable. Because had the person or entity done what they should have done, or had they not done what they did, then this injury will not have happened or would not have happened, correct?
True.
So applying this in this case to the gentleman who was outside of his condominium and was walking on the sidewalk inside the condominium. He has no choice but to walk on it to get to his car, for example. If you filed the lawsuit, that means you have satisfied yourself. I know you have not taken the deposition of the condominium owner, and you did not take the deposition. You have not yet taken the deposition of the snow contractor. But my question is, you must have satisfied yourself at this stage, knowing that there was a duty, and that duty was breached. They should have done something that they didn't do, or they shouldn't have done something that they did, correct?
Right.
Okay, so tell us, what did the snow contractor and or condominium owner do or not do?
Well, what they failed to do is to remove the ice. Now, to determine if there's merit to a case like this before we file the suit, what we always do is get the weather records for the week or 2 weeks before the incident. And we want to make sure, first of all, that based on the weather records, there was ample opportunity to remove the ice. Because if it only snowed, let's say, that day that the gentleman fell, there would be very little opportunity for the management to remove the snow or ice from the sidewalk in the parking lot. Whereas if it had snowed, let's say, 4 days before, and that would indicate that if it was still present when he fell 4 days later, that somebody forgot or neglected to remove the snow and ice.
In other words, the law doesn't say you need to hold vigil every second, whether you are a store owner, whether you are a shopping center, whether you are a condominium. The law says, did you have reasonable time to make sure that the premises are safe? Just like when something falls at a mire, let's say off a shelf. Let's say something fell off a shelf, and 5 minutes later, somebody else is walking and trips over. You cannot say that Meyer was negligent because the law does not expect Meyer to be watching through a glass every second of every minute of every hour. The law says they have a duty to routinely perform inspections. Routinely, maybe every 15 minutes, depending on the volume of people, every 20 minutes, every half an hour, but certainly not every 5 minutes. And you're saying the same here too for the condominium and snow contractor is, did they have a chance, and you obtain the weather records, and from the weather records you can tell how long it's been since it's been snowing. Did they have a chance to come? If they did their job, would they had an ample chance to come and clean so that when this gentleman is walking, he is safe?
That's right. We call that notice.
That's called
the landlord has to have notice that there's a problem. If there's no notice, then there's no negligence.
Even of snow and ice, that's also called notice?
Yes.
Okay.
So that if it snows in the morning, let's say at 8 o'clock, and somebody steps out of their apartment at 9 o'clock and falls, the landlord's not responsible for that.
Because an hour is not enough time.
Not enough time.
Not enough time. Okay. So do you say that the weather records in this specific case were extremely helpful in you making an initial determination to file a lawsuit?
They were very critical because they showed me that there had been snow accumulating for some days before.
Okay. How do you know, though, that prior to this gentleman falling, previously that day, somebody came and shoveled the snow? Previously, the night before, somebody came and shoveled the snow. Do you know that?
Well, we know that probably didn't happen because the sidewalk was covered with ice that morning when he stepped outside.
So you're saying that if it was covered with ice, that means that it wasn't previously cleaned up, because once you clean and you throw salt, it will melt.
The ice evaporates.
It takes several hours for snow to turn into ice, and certain weather conditions and a certain low enough temperature for snow to turn into ice.
Right.
So this issue, that's the whole issue here. The whole issue here is, did he fall? Yes, he fell. Is he severely injured? Yes, he is severely injured. The question, the big part of this case, correct me if I'm wrong, is going to turn on whether or not you can prove that the condominium owner and or through his subcontractors, there's one and the same for the purposes of this, should have done something that they didn't do, and had they done that something, which is cleaning the road, there would not have been ice for him to fall over. And that's the whole case.
That is the whole case.
That's the whole case,
In a
because
nutshell.
everything else, in a nutshell, because everything else is there.
Yes.
The injury is there.
No doubt.
It's just a question of putting a dollar amount on the injury.
Right.
اوكي سو رامي اول نقطة عم بسألوا عنها، في عنا كيس عم نشتغل عليه هو من الجالية يعني، ويمكن من المستمعين هون او عبر المستمعين، فما بدنا نعطي كتير معلومات we don't want to reveal يعني the identity. هيدا الكيس خطر جدا، وللأسف يعني هيئته جيد جدا قانونيا، لأنه الإصابة هائلة، ولأنه برأيه للمحامي هوارد رادنر ما في شك أنه الإهمال صار. هذا الشخص عايش بكوندومينيوم كومبلكس، هو from the east side من الجالية العراقية الكلدانية، عايش بكوندومينيوم كومبلكس، ترك الكوندومينيوم كومبلكس تبعه وماشي على اللي بنسميه common sidewalks. وقت اللي بتطلع من الكوندومينيوم بعد توصل للطريق ما بدك تمشي، ما بدك تنزل، بدك تمشي، هذا بعدك بقلب الكوندومينيوم. هدول بسموهم common sidewalks أو common areas أو common places. ليه common؟ لأنه هو بيستعملون، والشخص الثاني اللي بينزل من الكوندومينيوم تبعه بيستعملون، والشخص الثالث اللي بينزل من الكوندومينيوم تبعه بيستعملون. مثلا بقول بهوتيل الكومن اريا هي الانتري، وين بتفوت، شو بيسموها، ذا هول،
الصالة أو
الصالة.
نعم.
رايت. مثلا وقت اللي بتكون مستأجر بأبارتمنت ما عندك إليفيتر، هيدا كومن لكل العالم. ما بدك تنزل لتحت على المدخل، هيدا كومن لأنه كل العالم
استخدام مشترك يعني.
رايت. مشترك، وما في غير طريقة، ما في غير طريقة للخروج. هذا الشخص ظاهر من الكوندومينيوم تبعه وما عنده غير طريقة من انه تيوصل على سيارته، بده يمشي على سايد ووك. شو بيسموه سايد ووك بالعربي؟ رصيف.
نعم.
رصيف، ثانك يو. الرصيف ليوصل لسيارته. على الرصيف في ايس، مش ثلج، جليد. في فرق بين الثلج والجليد. في جليد، بسبب الجليد وقع، ضرب راسه، صار عنده تروماتيك برين انجري، صار عنده نزفان دم براسه، ونعمل له عملية وحالته غير جيدة بتاتا. هؤلاء الأشخاص وكلوا مكتبنا والمحامي هاورد رادنر اللي قدم الدعوة ضد شخصين. قدم الدعوة ضد صاحب الكوندومينيوم، وقدم الدعوة ضد السنو كونتراكتور. وبالنهاية نحن ما بنعرف مين اللي مقصر. يمكن الاثنين مقصرين، يمكن السنو كونتراكتور بس مقصر. بكل الأحوال أوقات وقت اللي بتقدم دعوة رامي وما بيكون واضح مين المسؤول أو كم شخص مسؤول وشو البرسنتج المسؤولية على كل واحد، بتقدم دعوة ضدهم كلهم، وبعدين بتصير بتشحل ايمات من بعد ما تحطهم بديبوزيشن وتسالهم مليون سؤال وتسال كل الاسئله اللي انت بحاجه تسالها، interrogatory questions, request for productions الى اخره. بيصير عندك معلومات اكثر وساعتها هون يا بتتركهم يا بتضيف عليهم عالم انت مش حاططهم، يا بتشيل من العالم اللي قايم دعوة. هلا هو قايم دعوة ضد الاثنين. سؤالي ليه؟ بيقول لأنه الجليد، الآيس، غير مسموح فيه، لأنه الطقس الجوي لآخر أسبوعين بفرجي إنه كان عنده وقت الكوندومينيوم كومبلكس إنه ينظف الثلج ويشيل الجليد. في فرق بين إنه تبلش تتلج الساعة 8 ويصير في إصابة الساعة 9 أو حتى الساعة 10 أو حتى الساعة 11، لأنه ما عنده enough notice صاحب الكوندومينيوم ليطلب الترك تبعه، ليجي الترك تبعه ليشيل الجليد الترك تبعه. نوتس مهم، يعني مش كوني فكانت. بس بما انه الوذر ريكوردز اللي حصل عليهم المحامي هاورد رادنر اثبتوا انه كانت عم تتلج على ايام عديده، يعني كان محضر هذا الشخص، يعني كان المفروض يعرف هذا الشخص لو شايل الثلج والجليد ما كان صار في جليد. لو عمل اللي لازم يعمله ما كان هذا الشخص وقع. يعني هيدا الإنسان الانجري تبعه كانت preventable. يعني هذا الإنسان لو الكوندومينيوم واللي معه عملوا اللي لازم ينعمل ما كان تأذى. يعني كانت الانجري تبعه preventable، يعني كانت الانجري تبعه لو انعمل الشغل مزبوط كانت ما بتصير. لهذا السبب نحن قايمين دعوة ضدهم. بعطيك مقارنة بمثلا ستور مثل ماير، العالم بتروح بتتبضع، أوقات شخص بكب أو بيوقع شيء من الشلف بالغلط وبيوقع على الأرض، ولا نقول وقع على الأرض وإجا شخص تاني مستهلك وزحط. هل معناتها أنه ماير مهملة؟ It depends. هل كان عندهم نوتس؟ هل كان عندهم وقت كفاية؟ القانون ما بيقول انه لازم انت كصاحب بزنس، ان كان شوبينج مول، ان كان ستور، ان كان بزنس، ان كان كوندومينيوم، القانون ما بيقول انه بدك تكون عندك نظارات وعامل سيرفيلنس سكند باي سكند لتشوف كل شيء عم بيصير everywhere. هيدا مش القانون. القانون بيقول هل انت بطريقة in a reasonable manner عم تتأكد انه the premises are safe. هل انت عم تعمل تشيكينج على الاماكن بطريقة متواصلة؟ الطريقة المتواصلة مش كل دقيقة او كل ثانية، كل ربع ساعة، إذا كنت مثلا ماير ستور، حسب إذا عندك عشرات ألوفات الأشخاص بيفوتوا بالساعة أو بالنهار بعتذر شيء، وإذا كان ألوفات شيء، وإذا كان ميات شيء. يعني الجواب مش دايما هو ذاته، بس السؤال هو ذاته إنه did they have notice؟ لأنه القانون ما بيقولوا لأنه وقعت لازم تنط هلا تنزل بباراشوت من السماء، وتنزل بباراشوت من السماء وتنظف. لا، بيقول القانون إنه هل عملت تشيكينج روتينلي كل ربع ساعة، يمكن كل نص ساعة، يمكن شوي أكتر حتى، لتتأكد إنه ما في شيء واقع على الأرض. لنقول شيء واقع على الأرض الساعة 9 الصبح، ومرق شخص تاني 9:10 وما شافه زحط. هل هيدا بيعني إنه ماير مهملة؟ لا، لأنه مرق فقط 10 دقائق. هون ذات الشيء مع الكوندومينيوم. الويذر ريبورت بيقولوا لنا إنه هو كان عارف بالثلج، عارف عم تتلج، عارف بدها تتلج. وين الاحتياطات اللي أخدها لسلامة المستأجرين؟ هون الغلط بهذا الموضوع. Thank you very much, Attorney Howard Radner. And I think that we are in the early stages of this litigation, correct?
True.
No depositions yet.
No discovery has been taken at all. Yeah.
How do you think that the snow subcontractor may have been negligent?
So a lot of condominium complexes will hire a snow contractor.
They're contracted with them.
Yeah, they'll contract with them, and they expect them, if there's a snow accumulation of 2 inches, to come out without even being called and to remove the snow. If there's ice, they're expected, according to the contract, to apply salt.
So one of the things you will be examining is the nature of the agreement between the condominium owner and the snow subcontractor. In other words, what did this condominium owner ask you subcontractors to do? Show up only when there are 4 or more inches of snow? Show up when there are 2 or less inches of snow? 2 or more inches of snow? Because that agreement, because the condominium owner may be looking to save money.
Yeah.
Correct?
Some of them, for instance, will ask the contractor to remove snow and ice from the lot, but not the sidewalks. The good contracts require the contractor to do both, but if the landlord wants to save money, he'll just ask the contractor to do the parking lots alone.
But of course, you and I are saying that would be negligent, because people can injure themselves just as much walking on the sidewalk as they are in the parking area.
In the eyes of the law, even if the landlord hires a contractor to remove snow and ice, the tenant or the condominium owner falls, and the landlord says, well, wait a minute, I'm not responsible for snow and ice because I hired a contractor to do it and he didn't do it, so sue him. In the eyes of the law, he does not have that defense, because the law says that the duty that the landlord has to remove snow and ice is not deligable. That means that even where he hires somebody to help him carry out his legal responsibilities, if the contractor does not do a good job, the landlord is still liable.
So, نقطة مهمة وحكينا عنها سابقا، إنه اللاندلورد صاحب الكوندومينيوم، صاحب البيت المستأجرين منه، صاحب الأبارتمنت كومبلكس المستأجرين منه، إذا القانون عاطي أو طالب منه مسؤوليات معينة، ما بيقدر يشيلهم عن ظهره لأنه طلب من حدا تاني يعملهم. خليني أوضح. لنقول مثلا condominium owner عنده واجبات انه تكون الاريا سيف، مزبوط. هو ما رح يعملها، هو رح يروح يتعاقد مع سنو سب كونتراكتور يقول له اعمل لي الشغل. لنقول سلم جدلا انه سنو سب كونتراكتور اهمل، يمكن ما تبع تعليمات الكوندومينيوم اونر، يمكن ما اجى نهار اللي لازم يجي الى اخره. هل بيقدر ساعتها صاحب البناء يقول ما انا عملت عقد مع سب كونتراكتور هو اللي اهمل، ما انا شيلوا هالمسؤوليه عني؟ القانون بيقول انه صاحب اجار ما بيقدر يشيل في بعض المسؤوليات. يمكن بيقدر يوكل حدا، بس إذا هذا الحدا غلطة هذا الحدا هو غلطه، ما بيقدر يشيل هاي المسؤولية عنه. يعني أنت عندك بناية، أنت مشغول، ما رح تنظف أنت التلج، تعاملت مع شركة بتجي بتنظف لك، سلم جدلا أنه غلطت، المسؤولية بعد عليك، مع أنه هي اللي غلطت. أنت تعليماتك إلها كانت صح، بس هن بيوم معين ما اجوا وصار في إصابة. هل أنت فيك تقول مش أنا الغلط، أنا قلت له 1 2 3 هو اللي غلط وهو اللي أهمل، قيموا دعوة ضد السب كونتراكتور؟ القانون بيقول نو، لأنه أنت كصاحب بناء، كصاحب عقار، في عندك non-deligable duties. يعني القانون بيقول فيك توظف حدا بالنيابة عنك، بس غلطه هو غلطك وإهماله هو إهمالك. So هون ذات الشيء. The duty is not deligable and that's by law.
Right.
What about when people come to people's homes and they get injured over snow and ice? What happens then?
Well,
it's very tricky, one.
That is a tricky. You're speaking about a private homeowner.
I am speaking about a private homeowner.
So we have the open and obvious doctrine, which would preclude the visitor from suing the homeowner in most cases.
Well, if it is open and if it is obvious. But what if the homeowner had snow and then had ice and then had snow covered? So you look on the floor, you see snow. You do not see ice because the ice is hidden under the snow.
Right. So under the Michigan laws, it's currently understood by numerous court decisions, if there are indicia,
meaning
of ice, signs of ice, then the ice is considered as a matter of law to be open and obvious. So for instance, if there's piles of snow on the grass, and there might be some snow on the sidewalk, but you can't see the ice, the law would say that the ice is considered open and obvious because of the presence of snow.
Does it matter if you go to somebody's property by walking over the grass or by walking over the concrete leading to the garage, to the front entrance? Should you be going to the house a certain way for you to have any measure of protection or no?
Well, under the current law, if there's snow anywhere on the ground,
wherever it is,
you're most of the time going to be barred from suing the homeowner if you're going to visit him.
What about if you are, I think, what we call a business invitee, like say FedEx, Amazon, and they're dropping a box on your front lawn?
But again, the open and obvious doctrine is going to bar many cases. If there's snow present,
give us a case of someone you represented where you were able to successfully sue the private homeowner.
Well, there have been cases that we've settled that did not go to trial.
Okay.
In some situations, there was one case that you referred to me, for instance, where there was a dispute about whether or not there was snow and ice noticeable.
So dispute as to whether or not there was any indicia.
That's right. According to some witnesses, there were indicia of snow and ice. According to other witnesses, there were no indicia of snow and ice.
By the way.
And in that case, we were able to settle the case.
Take pictures.
We had pictures.
Okay.
We had pictures, but
this is disappearing evidence. So taking pictures the day an injury like this happens is extremely important.
Very helpful. Very, very helpful.
Yes.
Sure. Because otherwise we're just relying on weather records and we're relying on recollections of witnesses. Sometimes people who are testifying about weather conditions a year or two after the event.
That's true. That's true.
Yeah. So there have been cases that I've handled over the years where it was disputed what exactly the weather conditions were. So some of those cases we were able to reach a settlement.
How can you dispute what a weather condition was when you have so many resources available out there of getting weather reports?
The weather reports sometimes do not establish exactly what the conditions were at the time and at the locale.
So the locale.
Yes.
So it could be the city of Detroit, but not the city of Highland Park.
Yeah, I mean, weather changes.
Some cities, they don't have weather conditions too.
Well, I mean, the difficulty often is that there may be, let's say a day before the incident, there was some snow accumulation, but it's disputed whether or not that snow was still present on the day of the incident. Let's say there was no precipitation on the day of the incident, but there was, we know, according to weather reports, precipitation the day before. The witnesses will now testify whether or not there was snow or ice on the ground at the time of the incident. The weather records don't really tell us if there was snow and ice on the ground at the time of the incident. All they tell us is that there was precipitation the day before, and there's no precipitation the day of the incident. So it's disputed among the witnesses whether or not let's say the driveway was icy when the plaintiff claims that she fell. Some witnesses may say it was icy. Other witnesses might say, we looked at the driveway and it was completely clear. So now you have a dispute among the witnesses, and you can't get a clear-cut answer just by looking at the weather records.
We're going to translate this very important piece of information into Arabic because it is going to interest a lot of the listeners. Almost everyone who's listening owns a home, has people come to their house, whether friends, visitors, or people like delivery, United States Post Office, Amazon, FedEx, UPS, etc. السؤال اللي سألته للشخص اللي عنده بيت خاص فيه وفي تلج وفي جليد ممكن على الأرض تبعه، شو المسؤوليات القانونية تبع هذا الشخص؟ بفتكر عم يجينا اتصال. شو المسؤوليات القانونية تبع هذا الشخص؟ بيقول لي كقاعدة عامة إنه هيدول الدعاوي اللي تقام من قبل شخص وقع قدام بيت شخص تاني بسبب تلج أو بسبب جليد، كقاعدة عامة رامي شبه مستحيل إنه يربحوا الدعاوى. ليه؟ لأنه في doctrine بتطبقها المحكمة اسمها open and obvious. يعني إذا واضح إنه أنت عم تمشي على جليد، أو إذا واضح إنه كيف ما اطلعت يمكن في شي مكان مبين فيه جليد، كان فيك انت تتحاشى الإصابة. هيدي الدكترين كتير مأذية، وهيدي الدكترين غير منصفة، لأنه أوقات عن جد مش واضح، بس القانون بيقول لا واضح. يعني شوي بيفتكروك انت مثل الكلب بتمشي وحاطط منخارك بالأرض وعم تطلع على الأرض، بس الإنسان مش هيك. الإنسان بده يطلع قدامه، الإنسان يمكن ماسك السلفون تبعه، الله أعلم شو عم يعمل، حامل أغراض وبده يطلع لتحت. يعني الإنسان بده يطلع على الأرض وبده يطلع قدامه، ويمكن حامل أغراض إلى آخره. الاشياء مش دايما open and obvious، مش لهالدرجة. بعدين الإنسان بعيد عن الأرض.
ماذا لو كان طفل مثلا؟ الطفل ما عنده وعي. هلا بنسأله. Thank you very much. So هون ورح يقول لك إنه open and obvious to the reasonable person, to the reasonably lay person. يعني في كيس ما بتصدق، في كيس شخص أعمى تعرض لحادث لا slip and fall أو trip and fall، ما بتذكر. المحكمة العليا بميشيغان قالت the injury could have been prevented because the danger was open and obvious. How is it open and obvious to a blind person? I'll know the reasonable person, the average person is not a blind person. The average person is a person who sees. يعني عاقبوه لهيدا الأعمى اللي وقع بجورة
لأنه قال لأنه بيقولوا the reasonable person الشخص بالمعدل عنده القدرة إنه يشوف، ولو شاف كانت حاشا. Can you believe that? So هيدي open and obvious هيدي لمصلحة أصحاب البيوت ومش لمصلحة الأشخاص اللي بيجوا على البيت عم بيزوروا البيت إن كانوا أصدقاء أو إن كانوا business people إذا وقعوا. يعني ونحن ما بدنا أي صاحب بيت يعني يرتاح بهذا الموضوع، لا، لازم يعمل أقصى جهده إنه أول شيء لسلامة الآخرين.
طبعاً.
هيدي أهم شيء، سلامة الآخرين. وهلأ صارت سلامة الآخرين هن الأمازون وركرز والدليفري وركرز والكونتراكتورز وإلى آخره. يعني صار في مسؤوليات كتير كبيرة على صاحب البيت، لأنه عدد العالم يمكن خفوا بهالأيام، عدد الزوار اللي بيجوا بيزوروك سوشيالي، بس زادوا عدد البزنس انفايتيز اللي بيجوا to drop a box, to drop mail, to do some kind of work on your house. So لازم صاحب البيت ينتبه وما كتير يتكل انه open and obvious. وبركي ما كانت open and obvious، وبركي قدر ربح هيدا الانسان، وبيكفي انه رح يتأذى هيدا الانسان. وعلى فكرة الإصابات falling on snow and ice شغلة كتير خطرة، مثل الشخص اللي حكينا عنه اللي حالته عويصة، واللي عنده هلأ صار عنده hemorrhage، نزيف، وحالته عن جد عويصة. وما بدنا نعطي كتير معلومات لأنه هو شوي متقدم بالسن. قلت لك عن ملكة إنجلترا القادمة كاميلا باركر بولز. خيا كان بنيويورك سيتي من تقريبا شي 7-8 سنوات. طلبوا منه، كان بهوتيل one of the known hotels، طلبوا منه يمكن كان جاي for a function أو يحكي أو شي من هالنوع. طلبوا منه إنه يحكي، طلع خارج الأوتيل، وقع على الآيس، ضرب راسه، صار معه نزيف وتوفى. It's a serious matter. So نحن ك home owners ما بدنا نتكل انه قانونيا we're gonna be okay. بدنا نعمل اقصى جهدنا لنحمي سلامة العالم اللي بيجوا لعنا. اما بالنسبة للاشخاص اللي بيزوروا لازم ينتبهوا، لازم عن جد ينتبهوا قد ما فيهم. والقانون بيقول للأسف إذا شفتوا أي علامة بتدل إنه في سنو أو أن آيس، معناتها بدكم تاخدوا حذركم، معناتها أي إصابة حصلت يمكن تكون سببها سنو أن آيس، يعني كان فيكم أنتوا تتحشوها، يعني it was a preventable injury. وناخد اتصال عنا 7 دقايق. هلو.
good afternoon.
يا أهلا وسهلا، مع مين عم نحكي؟
أحمد البياتي.
يا أهلا أستاذ أحمد، تفضل، عنا 6 دقايق، تفضل.
نعم, I have 2 questions. يعني one of them is related and one of them is a similar topic but is not really related to it.
Okay.
So the first question, if I hire someone to come every day and clean or take out the ice from my parking lot, my business parking lot, and I put in the contract that I will not be able to supervise his job, and removing everything, checking everything is his responsibility as a subcontractor. Is this will save me from
no.
a court suit?
The answer is no, because a landlord, and you are a landlord, has a non-delegable duty. His mistake is your mistake. His shortcoming is your shortcoming. His negligence is your negligence. So that means you'd better be using very good people, reliable people, trustworthy people. But let me have the expert here add to that answer.
Sure. In this
Yes.
Let him expand, and then you can ask your second question.
what type of business do you have?
I don't have business, but I work in safety related research. So this is just a question I have in mind.
Sure. So if
He
you
said it's a
hire a
business parking
contractor,
lot.
a parking lot for your business, for a business, the owner of the parking lot is going to be responsible for the maintenance of that parking lot, whether you hire a contractor or not. So if you hire a contractor and he does a poor job, you can still be responsible legally to somebody that gets hurt there.
Okay.
And your second,
Okay.
the
That's
second
because the duty is considered non-delegable. That means that you cannot get rid of your duty in the eyes of the law.
or your legal responsibility by
That's
putting
right.
it on somebody else.
That's right. You can't shift your duty to somebody else. You can hire somebody to help you carry out your duty, but you can't get rid of the duty. Even if he does a good job or a bad job, you're always going to be responsible if there was negligence either on your part or on the contractor's part.
Ustaz Ahmed, it's a lot like an employer-employee relationship. If any of my employees does something wrong, I am legally liable for that. I cannot say, well, I didn't do it, my employee did it. And here it's almost the same. Although I'm delegating a lot to my employees, please do this, please do that. But they make a mistake, it's my mistake. Although I didn't do it. Same here. The second part of your question, please.
It's not related to slip and trip, but it's just a question. I'm not sure if your guest can answer me. So 2 weeks ago, I get involved in a car accident because I crossed the red light traffic light.
So you were at fault. Okay.
I'm at fault, yes. But when I return back to the red light and I check it, I noticed the red light is some kind of, I'm not sure, it's get strong then weaker. So there's some mechanical issue with the red light. And this issue is only with the red light, not with the other, like not with the green or yellow one, just with the red. And there was a clear mechanical issue. So I record how the whole traffic light operate, and I show it to the policeman at that time, and he told me, yes, there is a mechanical issue with it. So in this case, is this the city responsibility to be sure all? Because I didn't see it, to be honest. And maybe because of this issue, maybe not. I'm not sure. But is this a city responsibility to be sure all the traffic lights are working in a good condition or something like this?
Well, for a car accident, your inquiry is one thing, and your inquiry may be another thing altogether. If you're asking for the purposes of showing that you did not cause the accident, that you're not at fault although you hit somebody, that's one thing. Is that
So
why
there's
you're
another
asking?
Factor, yes. So there's another factor contributing to what happened. And it's clearly there is some mechanical or some functional issue.
But let me ask you though, my question to you is, are you interested in this question because you want to be able to show that you did not cause the accident, you are not at fault for the accident?
I'm interested because I think I didn't see it. So I did not want
So you did not cause the accident?
Yes.
So you're not at fault in causing the accident? You shouldn't get a ticket, you shouldn't, okay.
Yeah, I don't see it. I did not see it at that time. And I think it's a contributing factor to what happened. It's not just because I decided not to.
So I will say, I will say two things because our time is a little bit limited. I will say, even if you are able to show that the city, subcontracted that work to somebody who did not do a good job, or there is something that is not functioning and it just happened. So they didn't have enough time to come and fix it. Where will that leave you? It will leave you as somebody who did not cause the accident because of an intervening event, because of a sudden emergency, because of something like that. So you're saying, you didn't really run a red light because it wasn't red. Let's assume that for a minute. So now you collided with another car, but you did not cause the other car the accident. Where that puts you is, certainly you cannot sue the other car. Certainly there is no other car for you to sue. And the other car cannot sue you for their pain and suffering because in that scenario, you did not cause the accident. How you go about proving that it was, the color, the shade, that it wasn't red is a completely different story. But it's not going to put you in an advantageous situation from the standpoint of a car accident because it will put you at fault and it will put you at a good disadvantage in that you did not cause the accident. Your insurance premium shouldn't go up. You shouldn't get a ticket. And the person who you hit should not sue you. This is all good, but it's not going to give you a cause of action against anybody for any pain and suffering. As far as the city, again, that they have noticed, let's assume that what he's saying is all correct, that it really wasn't red, that it was flickering some other color and what have you. Well, did the city have enough notice of that? Did anybody report it and in a timely fashion so that they can fix that. And and if you want to sue the government because of this accident, let's say you got injured, there is governmental immunity, and you have to show that the government was grossly negligent in that they knew about this flickering light. People reported it and they sat on it and did not do anything. And I know it's a very short answer, but our time is a little bit tight. And we thank you, Ustaz Ahmad.
شكرا Joumana, thank you so much. Thank you for sure for coming today. ونشكر لكل مستمعينا على حسن المتابعة. نلتقيك بكرة إن شاء الله.
إن الله راد قانون الضمان الاجتماعي. Thank you very much, Attorney Howard Radner. We very much appreciate
Well, thank you for having me. It's always a pleasure to be here.
Same here.